is still the case. But there are other pieces of information that the Commission has subsequently shared with us that may also need to be treated carefully. In particular, there is mobile data geolocation information which may or may not be projected. I don't know if my learned friend intends to project it on the screen when she makes her submissions. But if she does, the point that I would request the Commission to please consider and make a directive on is some of that information contains highly specific GPS coordinates. And the reason that when it is projected onto the Commission's screen, if the Commission intends on doing that, to prevent the publication of exact GPS coordinates is because it opens the threat that the GPS coordinates, when projected onto the screen, can be used to reverse engineer exact locations. Obviously, if the CCTV footage puts my client at a Durbanville mall, I can hardly complain about that. But I'm raising a concern in respect of the facility, for example, and geolocation data near the facility. I would also humbly request that in making such a directive, when my learned friend is going to refer to or reference the suburb that the facility is located in, that the name of the suburb is not mentioned explicitly, because it doesn't take a genius to run a Google search or a ChatGPT search to ask it what medical facilities are in the particular suburb, with the effect that it gets close to the very things that the chair has said should not be identified. So I don't know, practically speaking, when chair will make those directives or consider them, but I think even in just flighting the fact that those are the directives I'm asking for, I'm hoping my learned friend will approach it with some degree of sensitivity, even in the absence of a directive. That's not to say my learned friend mustn't say what she wants to say or use whatever footage she does. I'm just raising the concern about certain of the information which is not necessarily expressly covered by the in-camera ruling might nonetheless be utilized to undermine the very purpose of the in-camera ruling. And that's the second request that I make. Chair, I'm in your hands as to practically whether you want me to go
for now, yes, for now, please continue with your argument. I don't want to eat into your time. What we will do, we'll raise this issue before Ms. Hassim starts arguing.
I'm indebted.
Yes. I don't think there's an issue with the
first one.
The first one, really, but we can't make rulings piecemeal. Yeah.
Yes, indeed.
Yes,
indeed.
yes,
indeed.
Yes.
So that's point number 2.
Please continue.
Thank you, Chair. I'm indebted. Point number 3, now talking about the video footage. With all due respect, in light of the affidavits that have been exchanged between the respective parties, I'm going to respectfully submit that the video footage is unnecessary today. And more than being unnecessary, it's also not appropriate and does not serve a legitimate purpose. And there are 3 reasons why. The first one is, by and large, the allegations made by the Commission have now been admitted, answered to, and amplified by my client and the people deposing on his behalf. So the footage is not necessary because the footage is not needed to prove admitted facts. You don't need to lead the evidence to deal with admitted facts. That's point number 1 as to why it's inappropriate. Point number 2 is that the footage is an inappropriate form of evidence in light of the fact that, and you will know this because this is dealt with explicitly by my client's treating doctor, that things like video footage and geolocation footage or geolocation information and so on does not have clinical value.
Sorry, what noun did you use? It's inappropriate what? It's inappropriate? After inappropriate, what's the noun you use?
Oh, inappropriate form
Okay.
of evidence.
Oh, all right, thank you.
Appropriate form of evidence, because ultimately what underlies the Commission's concern and the Commission's complaint regarding my client's postponement is a medical issue. And so this geodata information or CCTV footage or whatever it is, on its own, not being led through a clinician, and not being analyzed by a clinician or responded to by a clinician, is inappropriate secondary evidence, which is being used to gainsay the medical opinion expressed about that exact approach.
Are you talking about Durbanville?
Yes, Durbanville.
Durbanville. Can you please explain your point about it relating to what may have to be attended to by a medical practitioner?
Yes. May I just ask Ms. Madlanga for some...
Because let me tell you why I'm asking you this. I see it as objective material which says he was there.
Yes.
So I don't see the connection with what a medical practitioner might have to say on the issue.
May I respond? Give two responses. The first response is that it's also accepted that he was there. So it's unnecessary because it's an admitted fact between the parties. There's no need to lead the evidence. But the secondary line of reasoning, and this is where I need Ms. Madlanga's assistance, but she'll hear me in response to you, Commissioner. I'll give you the reference after the fact, is this. The medical practitioner says that the Commission relies on a bunch of evidence, such as CCTV footage, Apple Pay data regarding payment accounts, movement data gleaned through geolocation data. And the position of the clinician, for reasons that you know which are recorded on the papers, is all that demonstrates is movement of some kind, but that the movement of some kind, the fact of the existence of the movement of some kind, is of no value in determining the clinical issue as to why the client cannot attend the Commission to give evidence. So the point as to inappropriate is that it doesn't deal squarely, with all due respect, with that clinical issue, and particularly in circumstances where the clinician has raised doubt about why it's being used in the manner in it's being used.
I get you on your first point, which is why flight that footage if there is no dispute about his location on the day and at the time. I get your point. I'm not sure that, one, you need the second point, and two, I am not subject to whatever else you may say. I'm not convinced by your second point. But please continue. But I stress that you don't, in the face of your first point, I'm not altogether sure that you need the second point. On this issue, it's a very weak point.
I think we're ad idem on the first point, and what I would say is that if those facts are not in dispute, then needing to flight the footage so as to prove something that's not in dispute is unnecessary. And
you see, your second point would make sense if the flighting would be for the purpose of showing that by being there, the medical condition relied on simply does not exist. If that was the purpose, I would understand your point.
Yes.
I'm not necessarily saying that Ms. Hassim is not going to argue that.
Yes.
I do not know what she's going to argue. But perhaps until she has argued that point, as I say, from where I'm sitting, I don't think you need the second point, and I repeat, I think it's a weak point for purposes of this should not be flighted.
Well, let me accept the invitation then to simply say, if my learned friend, well, I'm caught between a rock and a hard place, because during my learned friend's submissions, she may flight the exact footage to make the exact point that Chair is putting to me, which is because he was at X place, that brings into doubt the medical evidence. And in fact, that is the Commission's case, because in their affidavit, they call my client, with all due respect, gratuitously an inverse outpatient. To push that line of argument today in front of you, then I don't need the second point. But if my learned friend is going to push that point, then I do need the second point, even if Chair says he's not convinced that it's a strong one.
You see, just to make sure that I will not be misunderstood, the question whether Mr. Carrim's movements show a pattern that is at odds with what we have been told, that's central to the evidence leader's case. So what I said earlier did not suggest that Ms. Hassim is likely not to argue such a case.
Agreed.
But I'm making a different point. That case can be argued without the need to actually flight the footage.
Agreed.
Why not? Exactly because it's agreed that at the time, on the day, Mr. Carrim was at a shopping complex in Durbanville.
Agreed.
So that point can still be made, or that argument can still. But as I said, whether Ms. Hassim will actually want to flight the footage, we'll hear her when she says so.
Indeed.
Yeah. Shouldn't we leave it there and move on?
Yes,
please?
I'm happy to. Can I just give you one reference, if I may?
Yes.
If you look at paginated page 94 of your pleadings bundle in the postponement, paginated page 94, you'll see the heading, its geolocation data and its clinical significance. The basis for the submission that I was making to you comes from paragraph 45 on that page, as to why flighting that is unnecessary over and above the reason that Chair has already identified that it's not in dispute. So I'll just leave that, if I may. What Ms. Madlanga is doing is she's looking through the Commission's papers to give me the reference, the exact reference of where this debate arises from in the way that Chair posits it to me. So Ms. Madlanga will give me that reference shortly. Can I also just say this? This moves me on to point number 4. 23 minutes in. Point number 4 is this, is that the medical evidence in front of you from Mr. Carrim's treating clinician is undisputed on the clinical diagnosis and the clinical observations that Mr. Carrim's treating medical professional makes. There is an expert report, and I'm not even going to mention the expert's name, put up by the Commission, which generously doesn't actually dispute that clinical observation. What it does is it speaks to 2 collateral issues. The first one, which with the greatest of respect to the expert is an invention of his own, is he talks about it being inappropriate for Mr. Carrim's physician, Mr. Carrim's medical practitioner, to perform what is called an independent medical exam on,
in terms of which you get to
yes,
the whatever it is the medical practitioner
yes,
has to do.
Yes.
That doesn't necessarily answer my question, I don't think.
Well, the difficulty in answering the question is that I'm trying to distinguish what the Commission's expert report criticizes Mr. Carrim's medical practitioner for allegedly doing and why it's inappropriate. And I'm responding.
Let's take, for example, the context of criminal proceedings where the rule you are referring to would not apply at all. I would imagine that even in that context, you can talk forensic when medical practitioners
yes,
are involved.
Yes.
So it's on that basis that I'm saying, how would you describe or define forensic in a way that, for example, would exclude what we have been given here? Why is it not forensic here?
and that's the exact criticism that the Commission's expert attempts to make, is that the Commission's expert, as we understand it, says that the treatment Mr. Carrim is receiving can never be an IME exercise because he's not, in inverted commas, independent enough of Mr. Carrim. And the point I'm making is that's exactly correct, because the treating doctor is not performing an IME for some forensic, independent, objective, evaluative purpose, like under a Section 79 inquiry or under a Rule 36 type inquiry. He is the patient's, Mr. Carrim's, own treating doctor. So he doesn't, the point I'm simply making is that the basis upon which the Commission's expert, it seems to undermine the clinical evidence in front of you from that doctor is to say he's not entitled to perform an IME and what he's given you is not an IME. And we're agreeing with that because we're saying the treating doctor is doing something fundamentally different. So that's the first point that I was making.
Please continue.
The second point that I was making, to the extent that that report is relevant in front of you, is that that report itself emphasizes the role to be played by Mr. Carrim's own treating doctors before any such directive can be given that he's subject to the medical examination of another. And you can find that at Annexure MT1 at paragraphs 18 to 19. And it's also referred to in the evidence leaders' submissions at paragraph 47. So the very point is to say that the medical evidence of Mr. Carrim's doctor is unchallenged directly. To the extent it is challenged, it starts from an incorrect premise. But even if it does start from the correct premise, it emphasizes the very point as to the centrality of Mr. Carrim's own treating doctor and Mr. Carrim's treating doctor's clinical observations as it influences any future process. And you know Mr. Carrim's treating doctor's clinical view speaks to Mr. Carrim's non-ability to give evidence. And I'm using ability deliberately because that obfuscates what is known to us but not to the world at large. So it draws a point to say that the medical doctor's observations who's treating Mr. Carrim have a central role to play in any determination in how Mr. Carrim is treated. And we would say that the evidence speaks for itself and it's unchallenged in front of you. But there are a few more things I'd just like to say in that regard, if I may. The first one is our learned friends provided us a bundle of authorities. A lot of it is foreign authorities.
Before you go to authorities.
Yes, Chair.
I think the first point that doctor makes, that is Mr. Carrim's, is that, and I'm going to an assessment by an independent doctor. So Mr. Carrim's doctor says such an assessment, in fact, I think the doctor uses the word interpositioning. So if another doctor is interposed, that will be deleterious to the treatment that Mr. Carrim is undergoing.
Correct.
So the first point or the first prize is that no other doctor should be interposed. But as I understand it, your expression seems to suggest that I'm misunderstanding the situation. But let me continue. You will respond.
You and I have read each other's facial expressions for a long time now, Judge. You'll know what I'm talking about.
I know. Then the second point, as I understand it, is that if, despite my opposition as the doctor, as the treating doctor, if despite that the position is that another doctor should be interposed, that should be done in, I'm paraphrasing here, forgotten the actual wording, that should be done in consultation with me. I should be involved. As to how exactly, I'm not altogether sure now, should be done in consultation with me. Now, what I wanted to raise is, if the doctor does say that as an alternative, would Mr. Carrim oppose this? That is the alternative. Would Mr. Carrim totally oppose it?
Well, I have no instructions on that. And as you know, the legal team have had to obtain instructions.
No, in the manner in which you and I know yes, how this is.
So I would have to take an instruction. But if I may, I don't know if you are done, Chair, and I don't want to interrupt you.
Yes,
but
yes.
Having regard to my facial expression earlier, the reason that it was of that kind is, if you can go to the paginated pleadings, please, paginated page 49.
Yes.
If you look at the heading just above paragraph 68, the consequence of compelled attendance. So I think how I fairly read, how I understand the treating doctor's position is this. And I think, Chair, this goes back to the debate you and I had last time. And can you draw any inference from a compelled attendance where it's chosen not to attend, or a voluntary attendance? The position of the doctor is that it's not to say that none should be interposed as a blanket position. It's to say none can be interposed unilaterally or in a compelled sense that the doctor resists. And then the doctor's position in respect of what then, so in other words, if it's voluntary, does it come through me or whatever?
No instructions.
Yes.
Okay. If we were to say, please get instructions, by when would we get a response on that?
I can't commit, because it would have to be relayed to the two individuals who would then have to engage with Mr. Carrim when he's available, and then have to come back to us as the legal team. As you know, one of the issues is that in present circumstances, we don't have direct access.
But I would imagine, on my understanding of the protocol, the existing protocol, surely there must have been a good few interactions following that protocol. I would imagine that should give you an idea of possible time frames.
No, because in as much as I thought advocates were busy and have busy diaries, I've never dealt with medical professionals whose diaries are even more challenging than ours. And that's why, for example, some of our papers reached late because of when we could consult with the medical professional in particular concerned. Can I say this? In principle, on what's in front of you and what the doctor himself has said, there should be no objection. But that's obviously subject to his ability to speak on behalf of Mr. Carrim with or without Mr. Carrim's consent. Whilst maybe my learned friend is on her feet, so to speak, proverbially, maybe what I can ask is Mr. Bismillah, who's sitting behind me and from my instructing firm of attorneys, can try and get in touch with our other attorneys and the relevant individuals to try and take a specific instruction on what Chair has put to me. That's the best I can offer in the circumstances.
I must make the comment that what you've just said now is quite useful, which is that there is no in principle objection to the idea.
Well, because from my reading of what the doctor has said, is his opposition, in inverted commas, was on the unilateral imposition of a third-party medical practitioner. But the doctor has himself spoken about less intrusive means in a multitude of manifestations. And if the doctor interposing in respect of a third party to obtain voluntary consent, whether it's given or not given, is within the basket of those less intrusive means, as I see it, because it's not the compelled examination. And so that's why I say, in principle, I don't understand that could be an issue, but I will ask Mr. Bismillah to get the specific instruction.
Thank you. Please continue. Are you moving on to another point?
I see Commissioner Beloy.
Yeah, before you move on, let me just clarify. You and the chair seem to be of a common understanding of what the doctor is saying. So it may be I misunderstand. I'm looking at reading from 73.1 up to 73.3. I understand the doctor to say that there must first be engagement with him on these medical issues. And if we are not happy, and I'm reading now at paragraph 73.2, what is clinically objectionable.
May I ask for the page, please, Commissioner?
Sorry, 52.
Thank you,
52.
Commissioner.
73.1 up to 73.3, but the clarification that I would like to have is because of what he said in 73.3. He says a properly constituted assessment
stated to run Mr. Carrim's businesses in his absence. Now, if you look at which paragraph is it now? Let me see. Yeah, I think it's 20 something. Content of 25. Oh gosh, I've lost my place now, but you will all know what I'm referring to. I just have page 25 now. I would imagine. I doubt that it's there, but maybe it is. But the point is this. The deponent to Mr. Carrim's affidavit, the founding affidavit says, I do not know the auditors of Mr. Carrim's affidavits. I think I can mention that it's his wife. What the ruling says should not be mentioned are the names, I think, and other identifying features.
He also has two, so
one of the wives is the deponent. Thank you. So that's the wife. She says, I do not know. And she says, nobody else knows. So this means the virtual PA, who I assume that as a PA, she must be working very closely with Mr. Carrim. And the fact that she even assisted very closely when the bank account or bank accounts were being closed shows the proximity. I do not see the basis on which Mr. Carrim, with regard to who the auditors are, would have been cagey about that information. Not to the PA. I do not see how he would have been. Also, I may not be able, because I do not know the historical involvement of the person now running the businesses prior to him doing so after appointment. I do not know his historical involvement in the companies. But point is, once involved, what would be so difficult in him getting information with regard to these two issues, who the accountants are, and even getting copies of the financial statements. Just what would the difficulty be? Also, this person who's now running the businesses is not the only person. There are other people who have been in place working in those companies. That information cannot reside in Mr. Carrim's head only. I find that very, very difficult to understand. In fact, I want to say this or suggest this to you, Mr. Premier. You probably are aware of the Gauteng High Court judgment in the case of truth verification. If I'm not mistaken, I think it was written by an EL of AJ, not the old freaky EL of JP. And the principle enunciated in that case was later made or adopted by the Supreme Court of Appeal. But the point is this, and perhaps let me clarify upfront, that that principle relates to respondents who make fanciful or patently false statements on affidavit. And that authority, jurisprudential authority, exists because on paper, where you do not test the testimony of witnesses in a witness box, it's very difficult for courts to say that person is not telling the truth. But the usefulness of this authority is this. It says, if what a witness says is either fanciful or patently false, it should be rejected out of hand and on paper without the need for oral testimony. So even if, as I say, this principle has been used in respect of respondents, I do not see why it cannot apply to applicants as well. Where am I going with this?
Now, Mr. Carrim here seems to stand at odds with that, and the Commission must take whatever decision it wants to take regarding how it deals with Mr. Carrim in circumstances where it has direct evidence in front of it explaining his non-attendance, as it were. The last 2 points I'll make, and it is really the last 2 points, I'm 1 minute over time, is that there are many new allegations that are introduced in the answering affidavit of the Commission. And you know that on the papers, and particularly in the correspondence, I'm going to use my favorite A word again, there's a statement made about trial ambush in the sense that not the entire case is sought to be answered is made clearly for Mr. Carrim and his legal team and the deponents on his behalf to answer, and then they are ambushed after the fact to say that you've failed to answer this or that you're being deliberately misleading or inaccurate, whereas there are innocent explanations for these things. And if the Commission just showed its hand earlier, then it could have been dealt with earlier, and we wouldn't need to go 17 rounds in exchanging affidavits and supplementary affidavits, because we'd know the case to meet. Chair, you'd remember you said to Mr. Chaskelson the last time, put it on a piece of paper, those questions you want answered that were supplemented by Commissioner Khumalo. It's the same complaint, with all due respect, that we shouldn't be drip-fed information. We should know what the Commission has in mind so we can be helpful to the Commission in answering whatever we can, whenever we can. And lastly, may I just say that on the issue of the relief, the terms of the relief are obviously to be finalized, but on the underlying request for the postponement to a specified date or to some other date is ultimately unopposed. And that's Mr. Carrim's submissions in 1 hour and a bit. Thank you, Chair. 1 hour and 3 minutes.
Oh, thank you very much, Mr. Premier. Let me just take you to page 24.
I'm there.
Yes. Please read paragraph 67.2. And after that, 67.3.
Yes.
and also go to 71. Read 71. I'm not reading these because...
I understand why.
Chair,
yes.
sorry to interrupt, but what page are you referring to?
25.
I said 24 initially, and then I 24, page 24.
And all I point out is paragraphs 51.1 and 51.2, particularly the last sentence on 51.2 on paginated page 351, because that in part speaks to Mr. Carrim and the ability to obtain that information, and why even what has transpired before transpired in the way that it did. Insofar as the other individual which Chair mentioned, which is back at page 24, paragraph 67.3, if I'm not mistaken.
I think, was it not also 71?
Yes, no, 71 as well. That was on page. That was on page 25.
I meant paragraph, not page. Paragraph 71.
Paragraph 71, page 25.
Oh, okay,
which speaks to the same individual that is mentioned in 67.3.
Okay, yeah.
Yes. Again, all I would say regarding this expansive role that he's playing or he's not playing is look at the 5th line in that paragraph 67.3, starting with he does not make. And I would say that that sentence is a direct answer to the chair regarding what he knows or doesn't know or couldn't know. In particular, that...
Mr. Permit, providing information has nothing to do with making strategic decisions and new business decisions. It's historical information.
Yes, indeed, which is why the sentence I was going to direct you to, Commissioner Khumalo, reads in terms, given his age, he does not possess the institutional knowledge of the businesses that resides with my husband. So even if you're interpreting that first sentence against me about providing information not being strategic decision-making, which I can accept, the second sentence in particular speaks in terms to his ability to provide the information or otherwise. If you reject the explanation on paper, that's what you'll do, but that's the evidence you have in front of you. So also insofar as the same individual is named at paragraph 71, page 25 is concerned, you have to read those two things consistently with all due respect, which says that the individual concerned is doing nothing other than acting in a holding pattern or in a holding capacity, but doesn't have the institutional knowledge is just above the paragraph the chair referred me to, which is 66 on page 49, starting rather. And it's 3 lines. So why I point your attention to those paragraphs is for 2 reasons. The first one is you've heard me already. I'm not going to repeat myself, but Chair views those 2 other individuals who I'm not going to name as having a greater role perhaps in the running of the businesses. I pointed out the fact that according to what the affidavits say, that is perhaps not correct, but obviously Chair will make his own assessment. And then the second reason I'm pointing you to these particular paragraphs is to say that even if it's as simple, in inverted commas, for an instruction to be given by Mr. Carrim to those individuals, those 2 paragraphs need to be borne in mind in respect of the instruction and the ability to give that instruction.
How I read this is this. what comes before 66, which is the paragraph I referred you to, what comes before 66 deals with why Mr. Carrim would ordinarily not be in a position to be of assistance. But what is in 66 qualifies all of that. It even uses by contrast. So it's contrasting what's stated in 66. So you can't read what comes before the contrast in isolation, as it were.
Yes, but with all due respect, I think if you look at 67, for example, the next paragraph down from 66, and if you look from the fourth last line from the bottom, regarding what the doctor says is his clinical opinion, then what Chair says to me is the qualification in 66 in respect of what comes above in respect of 65, which is the paragraph I relied on, is itself further qualified regarding Mr. Carrim and his ability, and what the inherent risk is throughout the proceedings. May I ask?
The ruling, Chair, would you indulge me reading out paragraph 2?
Please.
Because then it might help the public also understand
Please.
why we're talking in this coded way. So paragraph 2.1 says the legal representatives of Mr. Carrim and the evidence leaders may not, during the hearing of the postponement application, mention Mr. Carrim's medical condition, the nature of the treatment he is receiving, the identity and nature of practice of the health professionals attending to Mr. Carrim in respect of the medical condition, and the medical facility where he is admitted. 2.2, publication or dissemination in any format of the information referred to in paragraph 2.1 is prohibited. 2.3, the legal representatives of Mr. Carrim and the evidence leaders may not, during the hearing of the postponement application, mention the names and residential and business addresses of Mr. Carrim's family members. That's the relevant part of the ruling. So, Chair, I am not going to flight the geolocation spreadsheets. They are in our papers. Everyone on Mr. Carrim's legal team side has seen it. The commissions have it. I don't think it's necessary to do that. I think if we were to do that, we would run into trouble. It's not possible to redact every single entry, and some entries are relevant to where perhaps Mr. Carrim's family members are. So we won't flight that either. So, Chair, and then consistent with this ruling, what I propose to do is, and I'm going to try to stick to a script a little bit, because when we are in open debate, then mistakes happen. With your approval, I intend to refer to the two doctors as Dr. Initial and Dr. Initial, to distinguish between the two. Would that be acceptable to the Chair?
Why not use first doctor and second doctor?
Okay. Okay.
And you can simply say, for example, first doctor being the one with the substantial reports that we have in front of us. And I'm not even sure who the second doctor is.
Could I say our doctor, our expert, and their doctor?
Good.
Something like that. Okay.
Thank you.
All right. So I'll proceed in that fashion then. I think the next and the point, and it was the first point that was raised, substantive point that was raised by a learned friend, was that somehow we're not really opposing the evidence leaders, the postponement application, but and that we've conceded something. I'm not sure how that arises. The heart of our opposition as the evidence leaders is that the Commission should not grant a postponement without requiring an independent medical examination. That is the heart of the opposition by the evidence leaders to a postponement. And the reason for that is because we've had a history of postponements where the length of time that we are told that Mr. Carrim will be incapacitated has varied and grown each time. So in the beginning, it was a few weeks, then it was 8 to 12 weeks, then it was 6 months in the latest round of affidavits. So it's very important to the evidence leaders that we have a fixed date for the postponement, number one, and number two, that postponement is conditioned on an independent medical examination. I'd remind the commissioners that this is the 5th postponement that Mr. Carrim seeks, and we've set out the history of the delay at paragraphs 7 to 24 of our written submissions. I'm just going to turn to those submissions. I don't need to go through the details. All I'll point out is that what one sees when one looks through the history of that correspondence and the postponements and the delays is that Mr. Carrim's attorneys seem to believe that a postponement is available for the asking. One example of that is at page 67 of the correspondence bundle. If we could just look at page 67 of the correspondence bundle. And if you look at paragraph 9, this is a letter that was dated 13 May 2026 from Mr. Carrim's attorneys. If you look at paragraph 9, it was again in an attempt to get a postponement of the next hearing. And all we are told in paragraph 9 is we confirm that we have now received the further name of the auditor. That's all. It's a very simple request. Why I say that I find it extraordinary is because that request was made as far back as when Mr. Carrim appeared in this commission. That was on 9 and 10 March. On 10 March, it was itemized. What the specific, it would form part of a list of requests that we had. We itemized the requests. In fact, I'm sure if we go back to the transcript of the 10th of March, somewhere towards the end of the transcript, it will be there. So this request is months old. That's the first thing I'd like to say. The second thing is that if we look at paragraph 66 on page 23, the paragraph reads the first sentence. In fact, let me just read the paragraph. Before 13 April 2026, before 13 April 2026. My husband was fully involved in his businesses. And then she explains now what that involvement entailed. But there's no explanation to us as the evidence leaders or to the questions that have been posed by the commissioners why these documents and this information could not have been provided between 10 March and 13 April. There's just no answer to that. Instead, what my learned friend does is he goes to the various paragraphs that have been debated just now. For example, on page 74 of the paginated bundle, where the chair, I think it was the chair who directed my learned friend to paragraph 40.1 and the person and the PA and the issue of the FNB accounts. And my learned friend tries to say, well, actually, it was just a rubber stamping exercise because all she did was place an electronic signature. That's not borne out by the text in that paragraph. That paragraph doesn't say that's all she did. It says that's one of the things she did, is that she appended an electronic signature. But that's not all she did. That's not what that paragraph says. What my learned friend is doing is with respect, taking liberties with the construction of these various paragraphs, and he's straining to defend an indefensible proposition that there is nobody in the company or in any of these companies which do business in the amount of hundreds of millions of rand who can say who the auditor is or where to find the financial statements. And I'll just make one last point because I mustn't, for the sake of completeness, on page 25 on the debate in paragraph 71, that his son has stood in for him. What that paragraph says is that he assumed overall responsibility for overseeing the businesses and ensuring that the operations continue in his absence. He is a central point of contact, attends to matters requiring attention, oversees the payment of expenses and the continued performance of existing obligations. And then read that with 67.3, which my learned friend went to explain, well, that the role of the son is that he doesn't make strategic decisions. Well, yes, that's true. 67.3 says he does not make strategic decisions or decisions concerning new business. So we're not making any queries in relation to new business. We're making a query that falls smack bang in the middle of what Mr. Carrim's son is responsible for, as articulated in paragraph 71. So those are our submissions on that particular topic. Now, I don't need to go there later on in my address. So, Chair, on the question of the redactions, we have no objection to that. On the question of the CCTV footage, what I'd like to say is that, and what I would like to make clear at the outset is that the point of the evidence on Mr. Carrim's movements is not put up to try to disprove a psychiatric diagnosis. It's not put up to...
Chair, I must just interject.
I